2, 1.
The Honorable Court of Appeals is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. Appreciate you agreeing to hear this matter via Zoom. I think it's the best way for us to keep the cases being processed in this unusual time we're living. So we certainly appreciate you participating. Having said that, a couple of things I need to share with you. Number one, we are to consider ourselves as if we are all standing in the courtroom here today. By that, I mean the same rules, procedures, and protocol will follow. Each side will have 15 minutes to make its oral argument. If you're the appellant and you've requested rebuttal time previously from the clerk, then you'll receive that rebuttal time. I do not anticipate any technological problems, but if something should occur, everybody just sit tight and don't get overly concerned. Number one, we'll get it fixed. And number two, we'll make sure that nobody's rights are prejudiced as a result of any glitches that we may have. Before we call the case, though, I want to take the opportunity to introduce your panel today. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the case?
No, Your Honor.
You may call the case then.
Ruby Bridges versus Randall Roth.
Thank you. We will hear from the appellant.
Good afternoon. May it please the court. My name is Ashley Satterfield, and I'm here on behalf of the plaintiff appellant Ruby Bridges. This is an appeal from Shelby County Circuit Court trial court decision granting a motion to dismiss of my client's complaint. It's a personal injury case. The lawsuit was timely filed about 2 weeks before the 1-year statute of limitations ran. However, service of process was not issued until several months later. That was done although the complaint had been filed. Counsel for plaintiff had been in communication with the insurance adjuster for the defendant and was given the impression that they were going to resolve this matter, and so process was not issued until those negotiations broke down. Once the complaint was served, defendant filed a motion to dismiss on the grounds that pursuant to Tennessee Rule Civil Procedure 4.013, saying that there was an intentional delay. We argue that the trial court erred in dismissing the case because the court did not consider our equitable estoppel argument, which essentially was that the defendant should be stopped from asserting the statute of limitations defense because they had given plaintiff the impression through frequent communications after the complaint had been filed, even post the 90-day deadline for service, that they were essentially waiving that statute of limitations argument. The trial court did not consider that.
When you say that the defendants gave you the impression they were waiving that, was this an evidentiary hearing? Were affidavits filed, or what was before the court?
There were no affidavits filed at the trial court. There was no evidentiary hearing held. It was merely the arguments of counsel on the issue.
Okay, and I assume you consider that to be evidence?
The testimony of the attorney as to the communications that they had with the adjuster, yes, I do.
I thought you said there was no testimony.
Well, let me correct what I said. My apologies. There was no testimony from counsel, but in the course of the oral argument on the motion to dismiss. And in the motion to dismiss as well, in the response to the motion to dismiss as well, there was argument as to what had occurred, but no one was on the stand under oath giving testimony.
Okay.
Nor the affidavits filed?
No affidavits were filed.
And you say that what was equitable estoppel asserted at this time?
Yes, in response to the motion to dismiss, and in that hearing, the court did not address that argument at all in their order
Was
denying.
a pleading filed, or was it simply argument?
It was the equitable estoppel argument was made in plaintiff appellant's response to defendant's motion to dismiss at the trial court level.
Okay. All right, you may proceed.
The plaintiff appellant the counsel for plaintiff appellant at the time had continued to negotiate with the insurance adjuster. I said based on that ongoing communication with the adjuster, it's the plaintiff appellant's position that they should be stopped from asserting a statute of limitations defense. In this case, those communications also, took place even past, like I said, the 90 days for service. And they continued to go on until the following year. So it's our position that the trial court erred, that the delay was not intentional, and even if it could be perceived to be intentional, that the defense should be stopped from asserting a statute of limitations defense because they gave the appearance through actions and inactions that they were going to waive any statute of limitations defense as we were trying to resolve the matter.
Did anyone ever, well, I don't want to get into the speculative, what the testimony may have been, but there was no agreement about this. Would that be accurate?
There was no written or formal agreement, correct?
All right, thank you. Go right ahead.
So based on what I just discussed, we respectfully request that the appellate court overturn the trial court's decision of dismissal in this matter.
Okay. You have about 4 minutes, nearly 5 minutes left, or have you concluded your argument?
Yes, I'm complete.
Okay, all right. We will hear from the appellee then.
Good afternoon. For the record, my name is Forrest Jenkins, and I represent the defendant, Mr. Roth. In preparing for this, preparing my response to plaintiff's appeal, it struck me that part of plaintiff's argument is that she conflates the defendant, Mr. Roth, with the insurance carrier, and that's simply not the case. But it goes without saying that settlement negotiations prior to suit and even after the lawsuit has been filed continue regularly between insurance carriers and plaintiff's counsel. That continues even after I'm involved sometimes. To say that simply by engaging in settlement negotiations leads the plaintiff.
Let me make sure I understand what you're saying. Are you saying that these conversations that appellant's counsel suggests we should consider were not with you, but were with a representative of the insurance company?
That is the case, Your Honor.
Okay. Go ahead.
And basically to say that negotiations with the insurance carrier would lead plaintiff's counsel or plaintiff to believe that that the statute of limitations was waived, that's a pretty slippery slope with that goes on all the time. Further, plaintiff's counsel has not provided any evidence that there was a tolling agreement or any kind of agreement between herself and the insurance carrier to waive the statute or prolong the statute. There's not been any evidence that they advised plaintiff or plaintiff's counsel that they should delay service of the summons, or there's not been any evidence of that. Frankly, the fact that the complaint was filed at all would serve as evidence that there was no belief that the statute of limitations was being tolled or waived, or that plaintiff had any reasonable expectation that it was being told or waived. As far as Your Honor, you've asked about whether there was evidence at court or affidavits at court regarding the intentional delay. Plaintiff's counsel admitted in open court and even in her argument that the delay was intentional because she has admitted that she was still negotiating. And while it becomes a little bit circular logic there, I don't think that we should be stopped from arguing a statute of limitations defense simply because that plaintiff claims they relied on it, but they've also admitted that she delayed it, delayed the service of the summons. I hate to speculate, but possibly it was delayed because that would require once the service was had, then that would require the services of defense counsel. An answer would be filed, discovery would be filed, and that would simply cause more work for plaintiff's counsel. On a side note, I wanted to state for the court that Ms. Satterfield did not have this case. Originally, she has taken it up on the appellate level. But regardless of that, counsel for plaintiff has stated numerous times that she intentionally delayed the issuance of the summons. Her whole argument.
Let me stop, Mr. Jenkins. And you keep referring to what the plaintiff's counsel admitted. Is that in the record? Do we have a transcript of that?
Your Honor, I believe you do. That was the transcript of the court proceedings was December 10th, 2020. And I believe it was filed with the court. Let me check on that, Your Honor. Yes, Your Honor. It was filed with the court on January 6th of this year.
Okay.
I believe that's right.
All right. You may proceed.
Yes, Your Honor. Claims counsel has cited some different cases to support her argument. Several of these can be distinguished. For one of the cases was Sparks versus Metropolitan. That was a 1989 case filed by a homeowner, a claim against an insurance company. Apparently, there was lengthy, years-long settlement negotiations in that, and the court held that that was substantial to let Ms. Sparks continue with her case. But it should be noted, Rule 4 was actually amended in 1995, and that case predates that amendment. Plaintiff also cites a UM case, UAM case, Ingram, another 1991 case. But in that case, I believe the attorney actually had evidence that they had agreed with the insurance company not to file suit altogether. There's no evidence of that in this case. Another case that is relied upon by plaintiff is Lusk. That's a workers' comp case in which payments were made by the workers' comp carrier. The plaintiff, I believe, maybe mistakenly, but to their detriment, relied upon those payments as workers' compensation payments. The court ruled that he was reasonable in relying upon that and not filing suit. That also that's a 1983 case. In the court relied upon Jones, and I think correctly, to show that anytime there is an intentional delay of issuance of the summons, as we have in this case, that does not toll the statute of limitations, and the plaintiff cannot rely upon the complaint, just the mere filing of the complaint, to do so. Unless you have any, your honors have any questions, I would rest.
All right. I see no questions. Ms. Satterfield, we will hear you in rebuttal.
Thank you, Your Honor. In rebuttal, I just wanted to speak to, with regard to the equitable estoppel argument, I think some proof of the inducement on the defendant's behalf is reflected in the fact that negotiations with the adjuster continue to occur beyond the 90-day issuance of the summons and into the next year. And had there not been sort of a understanding that the statute of limitations was to be waived, that adjuster would have stopped negotiating and said months before, this is barred by the statute of limitations. And that the adjuster did not. Those negotiations continued to go on past that date, had that been the expectation.
Satterfield, what proof regarding the substance of those alleged negotiations do we have in the record?
Unfortunately, I don't believe that we have any proof of those communications in the record. There is a communication from Nationwide that is in the record. It was an exhibit to the plaintiff's response to the motion to dismiss that shows Nationwide sending a letter, I believe it's January 10th, asking for more information regarding the bodily injury claim to see if we could get it resolved. So there's that one exhibit that is in the record, but I believe that is it.
Thank you.
Is there anything contained in that exhibit that could be considered as some type of agreement to withhold asserting this defense?
I do not believe there's specific language in that letter that would amount to what you're asking. I would say I think that the very fact that that letter was sent after the time had elapsed is evidence of what the intentions were, but I don't believe there's specific language in that letter to say, this is the firm agreement.
Okay, thank you.
So respectfully, plaintiff's appellant asks that the court overturn the trial court's decision and allow this case to proceed. Thank you.
Thank you. Thank you, counsel. We certainly appreciate your argument. We appreciate you participating via Zoom. We will take this matter under advisement and attempt to get you an opinion resolving it at the earliest time possible. Again, we appreciate it. Ms. Angie, if you will recess court to call the next case, please.
This honorable court is in recess until 2 p.m.
Thank you again,